Hey everybody, how's it going? Welcome back to Copper Jacket TV. So after nearly 10 years of waiting, I have been making videos about Duncan v. Bonta since about 2017. We finally have the decision in from the Banc panel of the Ninth Circuit Court of Appeals. So let's talk about what the decision was and what this means in Duncan v. Bonta. Finally, let's get to it. Now, real quick before we get started, if you believe that magazine bans are unconstitutional, make sure you hit that subscribe button. The thumbs up is always appreciated, and that little alarm bell will let you know when new videos come out. We're trying to get to that 600,000 number, so your support would be greatly appreciated. Okay, so let's go ahead and talk about Duncan v. Bonta and what the decision was. Now, we haven't talked about this case in quite a while. Just in case you're not aware of what this is a challenge to California's ban on magazines that can hold more than 10 rounds. As a matter of fact, this is the case that gave California its original Freedom Week. Freedom Week was a one-week period where there were no laws restricting magazine capacity in the state of California, and people emptied their credit cards. They brought them in by the millions. It was a fantastic week. Well, people got a taste of that freedom, and I can tell you right now, I was there. People wanted more. So this was a very big deal. It's been a very big case. As a matter of fact, Judge Benitez, also known as Saint Benitez, one of the reasons why is because of Duncan, but he actually found this case or found the magazine ban to be unconstitutional not once but twice, and this is its final time up to the Ninth Circuit. So now it's at the en banc panel. The en banc panel is a large majority of the Ninth Circuit Court of Appeals. This is basically its last stop. Now let's go ahead and take a look at the decision, and I'll show you guys exactly what happened. Okay, so here's a look at the decision in Duncan v. Bonta. Now, if you look at the top of the page, you'll see that this was just published today. As a matter of fact, it was just minutes ago at the time I'm making this video. Now, if we go down to the summary, that's where we get our decision. It says, the en banc court held that a California law banning the possession of large capacity magazines comports with the Second Amendment, reversed the district court's contrary conclusion, and remanded with instructions to enter judgment in favor of the Attorney General of the state of California. So playing complete partisan politics here and not actually looking at Supreme Court precedent, not actually looking at the Constitution and the text, in a 7-4 decision, the Ninth Circuit Court of Appeals upheld California's ban on magazines that can hold more than 10 rounds. Now, there were 4 dissenting judges in this case, and those 4 dissenting judges are as upset and mad as you could possibly imagine. As a matter of fact, Judge Van Dyke, in a video that I'll link down below, made a YouTube video where he actually talks about his dissent. He said that his dissent is so important that he didn't want to just simply write it down on paper. He wanted to give a complete video dissent in this case.
Hi, I'm Judge Van Dyke, and welcome to my chambers. I'm making this video as part of my opinion in the Duncan v. Bonta case. In this case, the state of California made the argument, which the majority has now accepted, that a magazine holding more than 10 rounds is just an accessory, not an arm protected by the Second Amendment's right of the people to keep and bear arms. I think anyone with a basic familiarity with firearms could show you that this attempted distinction is simply inconsistent with reality.
Just take a look at one of the dissents here. So it says, dissenting Judge Bumate, joined by Judges Ikuda, Nelson, and Van Dyke, would hold that nothing in the text or the country's historical understanding of the Second Amendment warrants California's magazine ban. Applying the Bruin framework, California's magazine ban is presumptively unconstitutional because the plain text of the Second Amendment protects the possession of magazines capable of feeding more than 10 rounds. California failed to overcome the presumption of unconstitutionality, where California failed to identify a historical analog that was relevantly similar to a ban on those magazines. Accordingly, he would hold that California's magazine ban is unconstitutional. So those are the judges that dissented. We have Budame, we have Ikuda, we have Nelson, and Van Dyke. Now, I know that a vast majority of you are not surprised by this decision whatsoever. As a matter of fact, I'm not really surprised by it either, even though I did hold on to hope because California didn't really have an argument that supported the existing law that banned magazines that can hold more than 10 rounds. They just didn't have any type of argument, no historical analogs. They didn't really have anything at all. So the judges in this case really had to do some mental gymnastics in order to make this work in their favor. But they completely ignored Bruin. They completely ignored Heller. These are in common use for lawful purposes. Clearly, any of us can see that. And they, again, they did their thing. They made their word salads, and they said in a 7-4 decision that they're not protected by the Constitution, apparently, because they're allowing California to ban them. Now, believe it or not, there's actually a bright side here. This case is absolutely ripe for the Supreme Court. There has not been a case in existence up until this point that is more perfect for the Supreme Court to take, because we have multiple decisions within California of differing opinions. We have a district court judge that said that the ban was unconstitutional on multiple occasions. We have the Ninth Circuit that says they're constitutional. We have these dissenting opinions. The case is done en banc. It is ready to go for the Supreme Court. So I think that this would be a perfect case to appeal to the Supreme Court, and I just don't see how the Supreme Court wouldn't take it, because again, we have a case that is all done and set and pretty much just ready for them. So instead of overturning California's magazine ban, let's go ahead and put it up to the Supreme Court and overturn all mag bans across the entire country. So anyway, I wanted to let you guys know about that. The Ninth Circuit strikes again. The most overturned appeals court in the entire country has decided that they would rather be overturned one more time than actually follow the Constitution, follow the rule of law, follow Supreme Court precedent, or anything else. This is outrageous. It's absolutely ridiculous. But this is what you get from that liberal Ninth Circuit court. So again, I wanted to share that with you. It's not the outcome that we were hoping for. It's kind of the outcome that we were expecting. But hey, let's go ahead and move this up to the Supreme Court. Thank you all very much for watching. I'm sorry that this did not go our way. Again, I've been working with this case and following this case for the better part of a decade here on YouTube now. And I just am ashamed to see judges act like this. This is absolutely ridiculous. But again, I wanted to share that with you. Good news or bad news, that's what it is. Thanks again. You guys have a good one. Take care.